Hello, and welcome to my channel. I'm Leanne Newton, and we're going to recap on this week's drama with the Lively and Wayfarer case. You can also check out my threads on X, which were written in real time. My username is KiaraJ2001. I am not a US attorney. I'm qualified in UK law. Everything I say is my personal opinion as someone who understands and interprets the law. It is not intended to be legal advice. I would appreciate it if you could please like this video and subscribe to my channel. You can also press the notification bell to be alerted to future content. So we have Blake Lively filing for motions for sanctions against each Wayfarer party except Justin Baldoni, and Wayfarer's counsel were also included. Lively then filed a motion to compel Wayfarer to produce information about the investigation into her claims. Wayfarer filed an opposition to Lively's motion to compel the information from the investigation. The news broke that Brian Friedman withdrew the Venable and Swift subpoenas. Leslie Sloan filed a motion to compel James Vituska, the Daily Mail reporter. Wayfarer and Abel both filed oppositions to Stephanie Jones's motions to dismiss each of their claims. Lively is submitting a further response, and Wayfarer were wrongly accused of lying. And finally, the source of the leak was revealed. So firstly, we have Lively and Reynolds' files for motion for sanctions. This is not new or related to last week's motion to strike. The letters in this filing between the lawyers are dated the 23rd of April. In a nutshell, Lively is complaining about the fact that the pleading is a group one. She is saying that Abel and Nathan are claiming tortious interference for a contract that had nothing to do with them. It was Baldoni's contract with WME. They're also saying that the parties, except Baldoni, have sanctions requested against them. Hello and welcome to my channel. I'm Leanne Newton, and we're going to recap this week's drama with the Lively and Wayfarer case. You can also check out my threads on X, which were written in real time. My username is KiaraJ2001. I am not a US attorney. I'm qualified in UK law. Everything I say is my personal opinion as someone who understands and interprets the law. It is not intended to be legal advice. I would appreciate it if you could please like this video and subscribe to my channel. You can also press the notification bell to be alerted to future content. So a lot happened this week. Blake Lively filed motions for sanctions against each Wayfarer party except Justin Baldoni. She also requested sanctions against Wayfarer's counsel. Blake Lively then filed a motion to compel Wayfarer to produce information about a private investigation into her claims. Wayfarer then responded to Lively's motion to compel the private investigators. We had news breaking then that Brian Friedman withdrew the Venable and Swift subpoenas. Leslie Sloan filed a motion to compel James Vituska, the Daily Mail reporter. Wayfarer and Abel both filed oppositions to Stephanie Jones's motions to dismiss each of their claims. Lively is submitting a further response to Wayfarer for the motion to compel. Wayfarer were also wrongly accused of lying. And finally, the source of the leak to Brian Friedman about Taylor Swift was revealed. So first up, we have Lively and Reynolds' motion for sanctions. This is not new or related to last week's motion to strike. The letters in this filing between the lawyers are dated as far back as the 23rd of April. In a nutshell, Lively is complaining about the fact that the pleading is a group one. She is saying Abel and Nathan are claiming tortious interference for a contract that Baldoni had with WME, which was non-existent to them. She is also saying that the parties, except Baldoni, have sanctions requested against them, are claiming defamation for Ryan Reynolds allegedly calling Baldoni a sexual predator. What is happening is Lively is trying to get out of the Wayfarers lawsuit against her and recycling her arguments in her motion to dismiss in an attempt to get sanctions. And this is not permissible under Rule 11. The main problem Lively appears to have is that the Wayfarers' complaint against her is a group pleading. I'm confident that the judge was going to ask Wayfarer to correct this in a second amended complaint as an outcome of the motions to dismiss. The quotes that Lively and Reynolds are complaining about from Brian Friedman were not made part of any pleading and are therefore outside of Rule 11. I'm optimistic. I can't guarantee how the judge will decide, but I feel like Lively falls flat with this motion. She appears to be attempting to use the motion for sanctions to give a false impression about the merits of her claims. The statements he complains about, Reynolds now, from Brian Friedman, the only difference between these two motions is that Friedman's statements, which the parties are complaining about, are tailored to them specifically. Wayfarer's response is the same letter. It rather efficiently addresses both Lively and Reynolds at the same time. Hello and welcome to my channel. I'm Leanne Newton and we're going to recap this week's drama with the Lively and Wayfarer case. You can also check out my threads on X, which were written in real time. My username is KiaraJ2001. I'm not a US attorney. I'm qualified in UK law. Everything I say is my personal opinion as someone who understands and interprets the law. It is not intended to be legal advice. I would appreciate it if you could please like this video and subscribe to my channel. You can also press the notification bell to be alerted to future content. So we have Blake Lively filing for motions for sanctions against each Wayfarer party except Justin Baldoni. She also requested sanctions against the Wayfarers Council. Lively filed a motion to compel Wayfarer to produce information about the investigation into her claims. Wayfarer then filed an opposition to Lively's motion to compel. News broke that Brian Friedman withdrew the Venable and Swift subpoenas. Leslie Sloan filed a motion to compel James Vituska, the Daily Mail reporter. Wayfarer and Abel both filed oppositions to Stephanie Jones's motion to dismiss each of their claims. Lively is submitting a further response regarding the private investigator. Wayfarer were wrongly accused of lying. And then finally, we had the source of the leak to Brian Friedman about Taylor Swift revealed. So firstly, we have both Lively and Reynolds filing a motion for sanctions. Now, this is not new, and it's not related to last week's motion to strike. The letters in this filing between the lawyers are dated as far back as the 23rd of April. In a nutshell, Lively is complaining about the fact that the pleading is a group one. She's saying that Abel and Nathan are claiming tortious interference for a contract that Baldoni had with WME. So effectively, the contract did not exist to them, and therefore they cannot make this claim. They're also saying that the parties are claiming defamation for Ryan Reynolds allegedly calling Baldoni a sexual predator, which doesn't apply to the other parties. The arguments are not unreasonable on the face of it, but What is happening here is Lively is trying to get out of the Wayfarer's lawsuit against her, and she is recycling her arguments in her motion to dismiss in an attempt to get sanctions. This is not permissible under Rule 11. The main problem Lively appears to have is that Wayfarer's complaint against her is a group pleading, and I'm confident that the judge was going to ask Wayfarer to correct this in a second amended complaint as an outcome of the motions to dismiss. The quotes that Lively is complaining about from Brian Friedman are not part of any pleading and therefore outside of Rule 11. I'm optimistic, but I can't guarantee how the judge will decide. I feel like Lively falls flat with this motion. She appears to be attempting to use the motion for sanctions to give a false impression about the merits of her claim. Wayfarer's response to both Reynolds and Lively is the same letter, which is quite efficient. Lively then filed a motion to compel a third-party law firm. Some of the attachments are under seal, but it is well worth reading the ones that are not. There is a proper catfight going back and forth between the Lively lawyers and this independent law firm instructed by Wayfarer to investigate Lively's claims. I will leave a link to Court Listener in the description. Now, when I say claims, I mean her claim that she raised complaints and her claim that Wayfarer failed to investigate and act appropriately. They are not assessing the substance of her sexual harassment or retaliation claims. Back in February, we saw a letter filed where Lively's lawyers complained that Lively had been contacted to investigate her claims, and Lively thought it was years too late. My understanding is that Lively had not asked for this. In her own letter, she implemented the return to protections instead of a more formal complaint. And in her own words, everything went smoothly from there on. I suspect because she had control of the film. Wayfarer and Sony have confirmed that Lively did not raise sexual harassment complaints with them. Anyway, upon learning of the lawsuit, Wayfarer instructed a neutral law firm to investigate her claims, as they are obliged to do. Lively complains that because Wayfarer is paying the bill for the investigation, the firm is quote-unquote bought and paid for by Wayfarer. Now, in the UK, the employer pays for third-party investigators or assessors as standard. So Wayfarer doing this seems normal and proactive to me. Lively says that this has come too late. She also says she would have cooperated if the investigation had been carried out at the time of the alleged sexual harassment. Now, I'm not convinced by this, given that she argues impropriety based on the fact that Wayfarer is paying the bill for the investigation. Someone has to pay the law firm for their services, and it would feel a bit retaliatory for Wayfarer to ask Lively to foot the bill. So I'm not sure what else she's expecting from them. Lively is arguing that it is both not fair that her claims have not been investigated, whilst also arguing that it's not fair that they are being investigated. Lively now does not want her claims investigated. She was invited to take part and give a list of witnesses who could have supported her claims, and she declined. She even sent a cease and desist letter to the law firm and falsely accused them of being Wayfarer's lawyers. Now, this is unpalatable for lawyers to be implying that fellow officers of the court are engaging in misconduct with no basis for that claim. Lively also sent the law firm subpoenas, and they refused to accept service. Having refused to engage in the investigation, Lively now wants access to the witness interviews and information. Lively's letter to the judge comes off as quite paranoid, suggesting that the law firm is, quote-unquote, acting under the guise of neutrality, which appears to be a bizarre claim to make with no basis for doing so. The filings, for me, are getting increasingly exhausting from her. So then we had Wayfarer responding to this motion to compel from Lively. They confirm in no uncertain terms that the first time Lively made these allegations of sexual harassment and retaliation was when she filed her CRD on the 20th of December 2024. Wayfarer confirms that nothing from the investigating law firm has been disclosed to them and that Lively is aware of this, as Wayfarer confirmed this to her counsel on May 10th. Wayfarer also confirms that if and when they do receive the documents, they will review and produce any non-privileged documents in accordance with their discovery obligations, and that seems reasonable to me. Wayfarer argues that they have retained counsel to conduct an independent investigation into Lively's allegations that she raised complaints, and Wayfarer failed to investigate. We get some great snark from Kevin Fritz, where he refers to Lively's allegations as new claims. This demand to hand over everything from the investigation could have the effect of chilling the investigation. Fritz specifically references the risk that witnesses could decline to come forward and speak out if they believe that their identities or comments could be shared with the Lively parties. He also says that it could impact the neutrality of the process, and that is a fair point. There is more snark, but also some very good points. Wayfarer points out that they could not have waived any privileges because they have not received anything to review and assert the privileges in the first place. They then have another dig at her new claims. Wayfarer let Lively know that the cases she has cited to support her motion to compel don't support her motion to compel. The reason for this is that the cases all involved defendants who expressly relied upon the investigations to defend their claims. Wayfarer do not rely upon this investigation for that purpose. They feel that their case is strong enough. This sounds incredibly confident, and I always love that. Finally, Wayfarer raises the impropriety of Lively circumventing the subpoena process. Again, she's issued a subpoena which has been properly objected to for work product and privilege. Instead of contesting the objection through the correct channels, Lively is trying to get the information by asking the judge to compel Wayfarer to turn over the documents, which they don't have. I can't see any reason why this shouldn't be denied. Then we had very big news. On the day this story broke, I was expecting Taylor Swift's response to her subpoena. I was at the time appearing as a guest on Zach Peters' show with Lauren Nidey when this dropped, so we were all able to cover this in real time. I'm going to put a link in the description to Zach and Lauren's channels and the video we were on. The subpoena served on Taylor Swift and her lawyer has been withdrawn. Why? It turns out that Brian Friedman got the information he was looking for, and more, apparently. Meanwhile, Lively put out a statement in response, which says, "We are pleased that Justin Baldoni and the Wayfarer parties have withdrawn their harassing subpoenas to Taylor Swift and her law firm. We supported the efforts of Taylor's team to quash these inappropriate subpoenas directed to her counsel, and we will continue to stand up for any third party who is unjustly harassed or threatened in the process." Now she sounds confused, and I believe that someone should probably tell her to hold off celebrating. She appears to be oblivious to the reasons for the subpoena being withdrawn. I'm also going to get on my soapbox a little because I don't appreciate the desperate effort from her to portray herself as a martyr, standing up for someone else when in reality she was just looking to save her own skin. I wouldn't bother reading the Deadline article on this, as they simply parrot Lively's view and bury the part about the information being shared. The Daily Mail covered this much better, and I'll leave a link to their article on this in the description. This was quickly followed by Venable confirming to the DC court that Wayfarer was withdrawing its subpoena, and then the Lively's also confirmed that they were withdrawing their motion to intervene. We then had Sloan filing a motion to compel James Batushka. I'm not going to go into a lot of detail here because I want to see Batushka's response to this. For the first time in this entire case, I'm not actually sure how I feel, who I feel did better here. They both have incredibly compelling arguments. So Batushka is saying that he's not going to respond to specific requests because of the fair reporting privilege and work product. And these are very strong protections, especially in New York. But Sloan also makes strong arguments. She argues that the privileges shouldn't apply because Batushka's text messages were put into Wayfarer's complaint, so they are at issue. Sloan also, fairly in my opinion, points out that she can't be expected to defend herself without having information about the comments she is alleged to have made. Sloan reasonably points out that he can't claim fair reporting privilege for a statement that he didn't report on, and she cites case law to back that up. However, Batushka does cure this by rightly pointing out that if Sloan wants to get the information, she can get it from Melissa Nathan. I need more information from Batushka's response, which is due on the 28th of May, as his request for an extension of time to respond was granted by Judge Lyman. But they were really good arguments from both sides, and it was really good to see, a more even set of arguments in a filing. So Wayfarer and Able filed their oppositions to Jones's motions to dismiss. Able starts by alleging that Jones, quote unquote, pillaged her communications. I have not seen that word in filings for a long time, but if all these allegations are true, then it's the perfect word to describe this. Able compares Jones to the Roman god Mercury. The reason I love this quote here is because if you look at how Mercury is depicted, he's described as the god of financial gain, commerce, eloquence, messages, communication, travelers, boundaries, luck, trickery, and thieves. He also serves as the guide of souls to the underworld and the messenger of the gods. It's easy to connect Jones in all of this. You can see the brilliance of the statement. Able explained that her communications were continuously synced to the cloud, and there was no way she was able to prevent it. She notes that she was never told that there were any advisories or restrictions on the integration of personal accounts. Able rightly points out that she did not expect her personal data would be subject to access or review by JonesWorks. She confirms that she specifically requested information and assurances from JonesWorks that her phone number would be released and received. She was assured all of this by the Chief of Staff. Able alleges that JonesWorks confirmed to Verizon that they were in the process of transferring Able's number before they ceased further communication. She further elaborates that because her accounts were logged in on the device, Jones was able to freely access her accounts at will. This is something that Jones admitted in her motion to dismiss was a possibility, but she did deny actually doing this. Abel also alleges that Jones knew full well that her communications would be used by Lively. She then goes over the Van Zandt lawsuit and the collusion between Jones and the Lively parties and states that Jones was monitoring and intercepting her messages until January 2025. Wayfarer states that Stephanie Jones has added information that is irrelevant and outside of the four corners of the amended complaint and suggests she has misled the court. I believe that this is largely referring to the preliminary statement from Jones at the beginning of her motion to dismiss, in which she told a tale of how Baldoni sexually harassed Lively, and Wayfarer and Abel covered it up. I said in my thread on Jones's motion to dismiss that I felt Jones was arguing Lively's case harder than Lively herself, and it appears that Wayfarer has taken a similar view and is asking the judge to ignore the additional PR fluff from her. Wayfarer alleged that Jones had not worked on their account for years before going on to address the dismissal of Abel and the sequence of events that led to Jones telling Sloan, who told Lively, who told Reynolds, who told the New York Times the contents of Abel's communications. Wayfarer then explained that Jones breached their confidentiality agreement by giving the Lively parties all their information. They alleged that Jones took Abel's phone number under false pretenses. They then addressed the quote-unquote lawful subpoena that Jones keeps referring to and advised that the sharing of information under the sham subpoena was the second time the information was shared, and the subpoena was obtained to give a retrospective cover for Jones sharing the information. Wayfarer then slammed Jones's flippant attitude to the allegations they made about these events in their amended complaint. The footnote also alleges that Jones's actions violate the contract for the same reason. They allege that the information Jones stole from Abel's phone is not the only information she shared with Lively. She also shared confidential, sensitive, and proprietary information about their account, and that is true. It was not just the text messages. Lively was given, the scenario planning and all kinds of other information that was specific to how Jones were operating for Wayfarer. Wayfarer alleged that Jones did not merely fail to follow their instructions, they gave 3 reasons for terminating their contract with her. 1. She breached the client confidentiality agreement. It seems like they terminated the agreement after Sloan's phone call to Nathan. 2. Jones acted contrary to the interests and goals of Wayfarer. And 3. Their agreement states that they will act in a professional manner and in accordance with the goals mutually established by Wayfarer and Jones Works, yet Jones fails to adhere to Wayfarer's instructions. There are a lot of facts at issue, so I don't think Jones is going anywhere. So this was a feel-good moment. Brett Dyer, who plays Michael Cordero in Jane the Virgin, and co-starred with Justin Baldoni, came out in support. I love Brett Dyer, and it was really nice to see him show some love for Justin Baldoni. I'll leave a link to the People article of this interview in the description. This annoyed me a lot. So, I'm seeing a lot of commentators who are erroneously saying that Wayfarer lied to the court. I wouldn't go as far as to say falsely in most cases, but it may be a misunderstanding. Wayfarer did not lie to the court. Blake Lively asked for information of the investigation from Wayfarer, and specifically she wanted notes, recordings, etc. of the witnesses. Wayfarer responded to say they didn't have that. This is part of Wayfarer's response to Lively, and it says exactly what she was asking of them. In Lively's new filing requesting permission to respond to Wayfarer, they include a privilege log which has been sent by the third-party law firm. This actually confirms for me that Wayfarer has not had the information Lively is requesting. So let's go through what the information could mean, because it's a description, so I can't say for definite what these things are. I can only refer to my own experience. So number one, that refers to engagement letters. Engagement letters are just letters that confirm that the firm has been instructed or retained. This is just initial correspondence. It has usually things like terms of business, charging fees, etc. This is something that all law firms should provide to anyone who uses their services. And this is not information that Lively needs. It's not relevant to the investigation. 2. So this is communications from Wayfarer to assist with the investigation. Logically, this is going to be likely to be witness statements or information from Wayfarer as the employer. Now, of course, they're going to participate in this investigation. The allegations are being made against them. The investigation is still ongoing, so this is likely not yet formed part of it, and currently it is not really relevant to Lively, but it may become relevant later. And that is exactly what Wayfarer says. They kind of their stance is, when we get it, we'll share it with you. 3. All of the notes, plans of actions, and summaries. It confirms that Wayfarer has neither sent nor received this information, so they clearly don't have it. 4. Documents regarding third-party witnesses and their counsel. Now, this is the information that Lively is really wanting. And here again, it confirms that in the sender-recipient copies section, it confirms that Wayfarer does not have this. So, yeah, as previous, Wayfarer will send this when they get it. 5. Status update requests and questions. When you instruct a solicitor or a barrister or a lawyer, whatever the terminology is, when you instruct, legal counsel, then you are going to sort of be making contact, which is nothing more than, where are you at? Do you have an update? You might have some questions, is there anything else like you need? Do you need the phone number of, any people? Do you need a timeline? These are standard questions. They're not part of the investigation specifically. And it's not really relevant to Lively, because what is part of the investigation, she will get in a kind of consolidated report with information later on when that is being compiled. 6. These are the internal notes between the actual investigating companies, because there's a law firm and then there's like a third-party investigating firm who are working together on this. So this will be either internal notes within the companies themselves, or it will be notes and communications between the two third-party investigating companies. It could be anything. It's unlikely to be relevant to Lively, but either way, Wayfarer do not have it. What I've done here is everything in yellow is what Wayfarer do not have, and everything in pink is what they have, but they're not really relevant to the investigation. So Wayfarer did not lie. Lively will get some information when it becomes available, but she can't just demand everything. The witnesses are likely to be staff of Wayfarer, cast, crew, people from Sony, SAG-AFTRA. There could be others, People who participate in these investigations are usually entitled to a level of confidentiality too. That's how whistleblowing situations, come into play, and they're obviously entitled to some protections. And certainly with the news that we've got about how Blake Lively behaved towards Taylor Swift, you can understand why it's not right for information to be divulged that unless it is absolutely necessary and relevant. We'll see how this unfolds. Wayfarer has agreed to share anything that is non-privileged, so I'm not quite sure what the issue here is for Lively. I am sorry, I'm stumbling over my words a bit. I've got a really sore throat today. So here we have the final bit of news. The source of the leak was revealed. It was Taylor Swift's father, Scott Swift, who reportedly went to Brian Friedman. Kudos to him. He did exactly what I would do if one of my kids, no matter how old they become, was used and threatened in that way. So there we go. We kind of saw this. We'd predicted this a little bit. Many of us had when the news broke of the extortion. So it is nice to see it confirmed. So that is it from me today. Thank you so much for joining me. And I will probably see you back on X with any new filings next week. I know we've got Stephanie Jones. She's going to be responding to Wayfarer's opposition and Abel's opposition. And we've got James Vichuska. So they're due. I think Vichuska is first on Wednesday and Jones's responses are due on Thursday. Other than that, it seems to be a bit of a free-for-all with all of these motions, so I could not even begin to tell you what's due and what might come. It could be anything at this point. So take care, have a great weekend, and happy Memorial Day to my American friends.